Hi, I'm Julie Watkins and I'm a Detective Sergeant based in the Adult Safeguarding Hub for Leicestershire Police. For the next 15 minutes or so, I will talk to you about Clares Law. Clares Law is also known as the Domestic Violence Disclosure Scheme, or DVDS for short. I will provide some background information about why we have Clares Law, as well as who can apply for it. I will also talk about what information can be disclosed and who will receive that information. Firstly, I will start by saying anyone has the right to know if their partner has an abusive past. This can also include previous partners or prospective new partners. Each application will be reviewed and considered. Clares Law was created to prevent future domestic abuse. A former loophole made it possible for domestic abusers or people with a prior record of violent or abusive behaviour to conceal their personal records. This meant that their partners were more likely to remain unaware of their past offences, and so were put at greater risk of future harm. Clare Wood, who the law is named after, was murdered in 2009 by her ex-boyfriend. Clare had met him on Facebook and was unaware that he had a criminal history when he befriended her. They began a 6-month relationship and Clare decided to end this due to his controlling and coercive behaviours towards her. However, he refused to move on and subjected her to further abuse such as harassment, damage to her property, threats of violence and attempted assaults. Though Clare had reported the incidents to the police, had provided a statement and also successfully got a restraining order, his behaviour continued unchecked. It finally ended with him taking Clare's life, followed by his own life a few days later. Investigations later revealed that he did have a history of violent and abusive behaviour, particularly towards women. It was also established that the police were aware of it but had not disclosed that information to her. Clares Law was formally rolled out in England and Wales in 2014. This was following a lengthy campaign by Clare's father, Michael Brown. He believed that Clare would not have lost her life if she had been made aware of his violent past. Now any member of the public has the right to ask the police about the criminal history of a partner they believe might be putting their own safety or the safety of someone they know at risk. Clares Law disclosures take into account different definitions of domestic abuse. Abuse isn't only limited to physical. It can also include harassment, stalking, verbal abuse, psychological threats or manipulation, as well as sexual assaults and violent behaviour. Anyone can experience domestic abuse, regardless of their age, race, ethnic or religious backgrounds, sexuality, class or disability. The police will take these different definitions of abuse into account when considering what information is to be disclosed as part of a DVDS application. The police will also consider online and financial abuse. Under Clares Law, there are 2 sections. The 2 sections are called the right to know and the right to ask. The right to know, this means that if police checks show that your current or ex-partner has a record of violent or abusive behaviour and they believe you may be at risk, they may decide to proactively share that information with you. They can apply on your behalf, or in more urgent cases, they can inform you verbally there and then. This information is provided to allow you to have sufficient information to keep yourself and child safe, or make an informed decision about continuing that relationship. The right to ask. This means that you can make a Clares Law application to ask about a current or ex-partner that you think might have a record of abusive behaviour or violence. You can also ask if behaviours have changed in your relationship and they are causing you some concern. There is a further option to ask on behalf of somebody else. This could be a close friend or relative who you think might be at risk from their current or former partner. Professional partner agencies can also ask on behalf of their clients or customers. All information provided is referred to as a disclosure. Even if the person does not have a criminal record, providing information saying there is no criminal record is still classed as a disclosure. When an application is made, research is then conducted into the named person of concern. This includes police checking national and regional databases. The information that is provided will be sufficient to allow a person to make decisions for themselves around their relationship and assist in keeping themselves and children or other dependents safe. All information will be reasonable, proportionate, and necessary. The information is confidential for that person and should not be shared with anyone else. If someone asks behalf of someone else, the information will be given to the person in that relationship, not the person asking. An example of that would be, if I had concerns for my niece and her new boyfriend, I would apply on her behalf. I would provide her details and the details of her boyfriend. I would also say why I was worried. This could be things like of how she presents, how he speaks to her, or sometimes it's just a feeling. I would not personally receive any information or disclosures, but my niece would be contacted and she would. It would be explained to her that someone has applied on her behalf. She would not be told who had applied. This remains anonymous. However, you could always tell the person that you are going to apply for them. That is if you feel comfortable and confident in that relationship. There are times when the information needs to be shared with professional agencies who are involved in the care and support of an individual. And an example of that would be a social worker supporting someone who may need to be aware of the safety of that person, or an IDFA could be present at the disclosure to emotionally support somebody going through a domestic abuse case. Each application is dealt with on its own merit, and it's dealt with sensitively and proportionately to that individual's needs. The disclosure is given verbally by a trained officer. No written documentation will be provided to that individual. When the disclosures are given, confidentiality is stressed to that person about not detailing what they have been told to anyone else. Should this happen, there could be repercussions for that person under the Data Protection Act. Following disclosure, safeguarding and referrals can be made by the officer if agreed with that individual. It is also really important to explain that this is a voluntary scheme. The person could not wish to engage or could withdraw at any time. We can also not dictate to individuals about what they should do with their relationship following the disclosure. We can advise them and support them, but not tell them what to do. Another really useful and important bit of information is to provide the police with a safe way of contacting that person that is not going to put them at any further risk. This could be a telephone number or an email address. Some examples of applications received are detailed on the screen now. One example is, I've recently started a relationship with someone I met a few months ago. He's been charming, but there are a few things that make me uneasy. He gets angry quickly and he's very controlling about who I talk to. I heard from a mutual acquaintance that he might have a violent past. I'm worried and want to know if he has a history of domestic abuse. I'd like to make a request under Clares law. Another example, I'm considering starting a new relationship. We're just friends at the minute, but I have been a victim of abuse in the past and I also have children. And last example is, I'm applying for my friend. She has been in a relationship with her girlfriend for the last 2 years and I just feel something isn't right about how she treats her. There are many other scenarios that could fit under Clares law, and the police will review and consider each application and its own merit. If you do wish to make an application for yourself or somebody else, you will need to do this online or by visiting a police station. All police area websites have a section dedicated to obtaining information from the police. For Leicestershire Police, if you go onto their website and search Clares Law, it will lead you to the correct form. If you do not feel confident or comfortable in using the internet, you can also visit a police station and an officer can complete this on your behalf. Thank you for listening, and I hope this was informative. If you have any other questions around Clares Law, please visit the Leicestershire Police website or contact the Adult Safeguarding Hub on the email address provided. Thank you.